Deus, o salutaris nostra, Dominex Deus, Ilinex Deus, Ilinex Deus, Deus noster, Icalorate, Dominex Noster, Avamanteri, Arcangeli, Ave Pateti, Ladamontemrem, Dominum Ino Maestatis,
Hey, how's everybody doing? Hope you're having a fantastic day. It is Monday, April 7th, and I have a really good one for you. I have an awesome one for you. This one's going to be great. This one's going to be fantastic. I love these sort of things. I think that honestly, really kind of upset about the way in which this is generally approached. A lot of times, what you get, and this is fine enough in theory, a lot of times what you get is when you want to talk about issues when it comes to the freedom of speech and freedom of religion clauses in the Constitution in U.S. law, a lot of times what traditionally minded Catholics want to do is they simply want to complain about the presence of the First Amendment. They simply want to cry about the history of jurisprudence in the United States. But I think that what we can do is we can be a little bit smarter about this. We can go at this from a slightly different angle. And what especially occasioned this is, if you guys remember, this was, I believe, 2 or 3 weeks ago, there was the Kansas City public black mass. So here you had in Kansas City a public blasphemy, the desecration of the Holy Eucharist. And you had a series of protests, very energetic protests from some awesome young Catholics. But this led me to want to do some research, and I've been researching this general issue for a while, but particularly research the history of blasphemy laws in the United States. Because I think this is important. I think that when it comes to the sort of long game that we have in the United States, it's a bit of wishful thinking that we're going to somehow overturn the First Amendment of the Constitution or overturn the 14th Amendment of the Constitution. And then from this point, we're going to be able to change the Constitution into a Catholic confessional Constitution. As awesome as that would be awesome. As amazing as that would be, unfortunately, this is not something which is realistic. So for the time being, if you want to bring about change in legislation, if you want to bring about change in jurisprudence, what you're going to need to do is you're going to need to work within the current framework. So when it comes to blasphemy laws, what is the history of blasphemy laws in America? Historically, what have constitutional scholars, what did the founding fathers, has the Supreme Court and other lesser courts, what have they said about blasphemy laws? Because many of you may not recognize this, but there's actually a very long history of blasphemy laws. And interestingly, the most important court case on this happens to be a application of punishment against somebody who blasphemed the Blessed Virgin Mary. So I'm going to go over everything today. We're going to go through a lot of the history. We're going to go through a lot of the reasoning that different authors give. And I want to give a caveat beforehand. And the caveat that I need to give is that when it comes to the broadly Anglo American jurisprudential tradition on the point of anti-blasphemy laws, while we both agree as Catholics and within the common law tradition, we agree when it comes to the fact of blasphemy laws, so there should be blasphemy laws. There is actually a slight bit of disagreement as to maybe the limits and extension of blasphemy laws, the reasoning for anti-blasphemy laws, et cetera, et cetera. So that's a point that I need to bring up. So every author that I quote and the justifications they give and the limits that they set, this doesn't necessarily mean that I myself personally or that I think you should agree with the reasoning that they lay out. So for us, for example, the bigger consideration for anti-blasphemy laws is not going to be the public order, although that commonly gets brought up. It's going to be the rights of God and the common good considered in our final end of the beatific vision. So first, what I wanted to go over is I kind of wanted to address the elephant in the room, because most of the time, if you're going to bring up something like anti-blasphemy laws with somebody, you know that straight what they're going to go for is they're going to go for the First Amendment. They're going to say, well, First Amendment covers freedom of press, freedom of speech, freedom of exercise of religion. It has the Establishment Clause. And what they're going to reason from this is they're going to say that because of all of these clauses in the First Amendment, that we're not going to be able to make anti-blasphemy laws. But when you actually look at simple history, when you look at the history of the way in which the First Amendment was interpreted, even by those who were integral in the drafting of the First Amendment, and you actually look at the prehistory of the First Amendment, because the First Amendment didn't just pop up after the Constitutional Convention when they were working towards its ratification. That's not when the First Amendment popped up. A lot of the constituent elements of the First Amendment go back centuries beforehand in the Anglo tradition. And in the Anglo tradition, for those centuries beforehand, they were punishing blasphemy. So what the heck is going on? And to give a weird illustration of this, there are actually only two major court cases, which directly rule against blasphemy laws in the United States. Neither of them are Supreme Court cases. One of them was a Pennsylvania state court case, and the other one was a district, a circuit court case. But when it comes to these court cases in particular, these court cases actually, one of them is in 1974 and the other one is in 2010. So before 1974, which is crazy, most of our parents were alive. Before 1974, there were not any major court cases ruling anti-blasphemy laws to be against the First Amendment or to be against any law. Closest you get is you get a case in the 1950s that happens to rule that when it comes to films are protected under the First Amendment. And the occasion for this happens to be a scandalous, blasphemous film. But the court case didn't at all rule against blasphemy laws. So if you think about it like this, I mean, 2010, I remember 2010 very clearly. Most of you, at least who are alive in 2010, most of you remember 2010 very clearly. 1977, first court case, most of our parents were alive during this time. That's crazy. And even after this, you still have, even after the 1974 ruling, you have other lesser courts ruling in favor of anti-blasphemy laws. So if you think about it, it's really only been a generation or two where these anti-blasphemy laws have been regarded or seen in the public eye as being unconstitutional. There isn't even a Supreme Court case against this directly. So technically speaking, there's multiple different states with anti-blasphemy laws on the books. Technically speaking, in those states, if a prosecutor wanted to prosecute, they could do so. You have, I believe, it's 5 states still without court proceedings against those laws. They could absolutely be applied currently. Now, obviously, I think it would be disputed within the courts, and I think there would be a major, there would be something major which would come from this. But really, the position we're at right now, we're actually not in an incredibly unfavorable situation towards anti-blasphemy laws like there was, for example, with anti-abortion laws before the Hobbes decision. There's nothing in the U.S. Supreme Court decisions against anti-blasphemy laws. In fact, there is plenty of preceding legislation from the U.S. Supreme Court defending anti-blasphemy laws, which I'm going to quote some of those. But part of the ridiculousness in this way of argumentation, besides the fact that you had these centuries of anti-blasphemy laws being applied in the United States after the First Amendment was ratified, is you actually have to look at those who were responsible for the drafting of the First Amendment and those who were responsible at the state level for the um, drafting of the First Amendment, and those responsible for the ratification of the First Amendment at the state level, the state conventions that had to ratify the Bill of Rights. When you look at these individuals, when they went back to their states, because before that, they basically ran off, before the founding of the United States, they basically ran off a system of common law, and there was some sort of ratified laws, but they had to go back to their states, or maybe previously, after the Revolution, they had to make codes of laws. These very individuals who were ratifying the Bill of Rights, when they were at the state level, were making anti-blasphemy laws. I mean, in some of the states, it was imprisonment. Some of them, there were fines. Traditionally, in some states, it was the death penalty, public flogging. I mean, these type of penalties against blasphemy. So there's actually a very interesting article from the Harvard Law Review. I believe it was like 2 or 3 years ago that it was written. And it's kind of funny because it's meant to be like a little bit of an own at originalists, those who want to read the Constitution in accordance with the original intent of the authors. And it's like, well, if you follow through with what you believe, obviously you would have to allow anti-blasphemy law. So I read it as a little bit of a dig at this, but for me, I'm like, okay, well, yes, correct. You forgot the Giga Chat on that one. So what this article states is it actually lists through all the states and the type of laws that they gave. So it says, quote, from the founding era, when the country ratified the First Amendment through Reconstruction, when the 14th Amendment applied to the federal free exercise clause to the states, I think that's fake. Americans viewed blasphemy prosecutions as compatible with free religious exercise. The same state legislatures that ratified the free exercise clause passed statutes that criminalized blasphemy. And the same public that ratified the state religious freedom provisions convicted defendants charged with blasphemy. The courts thus developed a body of religious liberty doctrine that was firmly established by the Civil War. Whether the relevant constitutional moment was 1791 or 1868, the Free Exercise Clause, as originally understood, posed no barrier to prescribing blasphemy. Along with the general public, the legislators that ratified the First Amendment treated blasphemy prescriptions as compatible with religious freedom. 2 years after Massachusetts adopted its 1780 Constitution, including a religious liberty provision, it enacted a blasphemy statute. Many members of the convention which framed the Constitution were members of the legislature which passed the law. Under this law, Massachusetts successfully prosecuted blasphemy in 1790. Similarly, pursuant to New Hampshire's 1784 Constitution, which recognized religious liberty, the legislature passed a 1791 blasphemy law. Vermont's 1793 Constitution, guaranteeing free exercise, was followed by a 1797 blasphemy statute. New Jersey's legislature followed the same pattern under its analogous constitutional provision. And after Pennsylvania passed a 1790 Constitution securing religious freedom, a Pennsylvania jury convicted a blasphemer in 1799. And what you guys need to remember is that when it comes to this first generation of legislatures, of constitutional conventions, which were following the American Revolution, this wasn't just this era that was prescribing blasphemy, that was punishing blasphemy, that was making laws against blasphemy. There are blasphemy laws which are passed from then up into the 20th century. There are blasphemy laws, like I said, the 1970s, the Pennsylvania legislature in the 1970s was passing a blasphemy law. There are blasphemy laws which go well past this era. This isn't a relic of the past. You have people in the 1920s still being jailed for blasphemy. After this point, it kind of turns over into basically fines or some sort of non-allowance of certain acts like registering company names which have blasphemous language in it, for example. But you have throughout the 1950s, throughout the 1960s, throughout the 1970s, you have courts upholding blasphemy laws. Yes, you have certain lesser courts which speak against blasphemy laws, but the vast majority of courts are ruling in favor of these laws. Legislatures are making these laws. There's nothing from a universal level which somehow prescribes against these laws. So you have in the Harvard Law Review article, it puts it like this: "Quote, only meager precedent, a federal district court decision and a state intermediate appellate court decision has directly held anti-blasphemy laws unconstitutional." So basically, when you look at precedent against these laws, which would be able to state that this is somehow unconstitutional under the First Amendment, there's basically nothing. The vast majority, dozens and dozens and dozens of different cases, some from the highest levels, are supporting anti-blasphemy laws in the United States. The universal consensus of the legislative body. You have bodies. You have common law from before the ratification of the Constitution. You have all very significant and weighty evidence which is supporting the allowance of this type of blasphemy laws. There's literally nothing which is supposed to stand in the way of these. So I gathered a few of these court decisions, a few of the major ones, in case you guys wanted to read them. So what I think is the most important one, it ends up being from Justice James Kent in New York, and then who is the Chief Justice of the New York Supreme Court, in People versus Ruggles, Ruggles, really weird name, and this was from 1811. And why this is important is Kent, he wrote his commentaries on American law. I think it's called Commentaries on American Law. They call him the American Blackstone. If those who don't know Blackstone, he was basically the authority in English law, English common law, the top guy. He's like the St. Thomas Aquinas of English law. He's the guy that everyone looks to, everyone quotes in the Anglo-American tradition. But James Kent, they call him the American Blackstone because he did for English common law what he did for American common law what American law rather what Blackstone did for English common law. So he's extremely important. He studied under some founding fathers. He's the greatest legal scholar in American history, and he defended very strongly in two instances. So this Supreme Court case, and then also in the 1821 New York State Constitutional Convention, he supported very strongly anti-blasphemy laws. He said it's a complete bastardization of the Constitution. He literally knew the guys and studied under the guys who were ratifying the Bill of Rights. So it's a complete bastardization of the Constitution and of our legal tradition to say that blasphemy laws are somehow revoked. It's completely ridiculous. And then you get the second case, and I chose this one deliberately as well because this is a Supreme Court case. It's Vidal versus Girard's executioners, executors. Sorry, not executioners, executors. Again, weird name. Why do all these people have weird names? It's not like Johnson or something. It's all these people weird names. Joseph Story. It's in 1844. And the reason he's important, he's one of the greatest. Just like for Kent, when it comes to American law in general, jurisprudence in general, that was Justice Joseph Story when it came to constitutional law. He was extremely well respected. And he defends the existence of blasphemy laws, specifically drawing from the United States as a Christian nation. So there's different coloring that you get from some of the justifications. We're going to read some of them later. But he defended that in 1844. And then you have the U.S. Supreme Court does this again in Robertson v. Baldwin, where this one's important because it lays out some of the limitations and draws from common law to show these limitations that are implicit in the Bill of Rights. So that's going to color the argument very nicely. And then you also have the Maine Supreme Court in State versus Malkus, which defends the jailing of blasphemers. That's why I added that, because it's awesome. And then you have in the 1940s, and this one's awesome as well. They're all awesome, of course. You have the 10th Circuit Court in Oney versus Oklahoma City. This is specifically about the Jehovah's Witnesses, which makes it really cool. This was in 1941, so this is like your grandparents. Many of our grandparents were alive in 1941. Strong defense of anti-blasphemy laws, and I think honestly this provides the most succinct description of the reasoning which is given in the Anglo-American tradition, which is why I included it. And then State v. Stolenberg from the Iowa Supreme Court. I included this one because it's the latest one, and this is in 1974. So when it comes to kind of shifting from the history of this to looking into the specific arguments which were given, generally speaking, the justification which is given is that when it comes to the First Amendment and when it comes to the entire Bill of Rights, the First Amendment and the Bill of Rights, these are not absolute rights. And what I mean by this is that each one of these rights, as stated, has some form of caveat. So, for example, the right to bear arms. It is not unconstitutional to say that a felon cannot own firearms because there's some sort of caveat which is implied in this. Or with freedom of speech, everyone knows you can't yell fire in a crowded theater. That's somehow going to be a caveat which is included. You can't speak in a libelous way. There's caveats which are included in the tradition, in the common law tradition, which has been recognized from the beginning and even from before the beginning of the United States. These caveats to these rights have been recognized. So this is very clearly stated in Robertson v. Baldwin, the U.S. Supreme Court case that I listed. It goes through a number of these caveats, which is very interesting to see. So it says, quote, "The law is perfectly well settled that the first 10 amendments to the Constitution, commonly called the Bill of Rights, were not intended to lay down any novel principles of government." So first, then this is very important in the Anglo-American tradition. We need to recognize that when it comes to these rights, which are stated in the Bill of Rights, these rights are not things which were invented by the ratifying commission. These things were not invented. It's not like they just made these things up because they were sitting around thinking they were like, oh, these are great. No, when it comes to these were not novel principles. These were principles which existed for centuries beforehand. And therefore, since the principles were stated for centuries beforehand, it is implied that also the caveats, the interpretation, etc., especially from Blackstone, that guy, these principles are to be included when we're interpreting these laws. It says, we're not intended to lay down any novel principles of government, but simply to embody certain guarantees and immunities which we inherited from our English ancestors, and which had from time to time immemorial been subject to certain well-recognized exceptions arising from the necessities of the case. So it says this isn't novel at all that we include exceptions to some of the articles in the Bill of Rights. This is not at all novel. This is something which we've always done. It would be ridiculous if we weren't to do this. Like, how would this even look like if we weren't to do this? For example, the free exercise of religion. Yes, it's part of my religion to murder somebody. It's part of my religion to commit adultery. Actually, wait, that's legal in most states. It's part of my religion to have multiple wives, Mormonism. It's part of my religion to do all of these things. So therefore, because of free exercise of religion, I should not be able to be prosecuted for this. Very clearly, you can have limitations to these rights, which are traditionally included alongside these rights, without somehow excluding these rights from existence. In incorporating these principles into the fundamental law, there was no intention of disregarding the exceptions which continued to be recognized as if they had been formally expressed. Thus, the freedom of speech and of the press does not permit the publication of libels, blasphemous, notice this is blasphemy, blasphemous or indecent articles, or other publications injurious to public morals or private reputation. And notice this is going to be the statement that we're going to hear over and over again. To public morals, the public good, etc., etc. because certain speech is going to be deliberately meant to injure the common good. And this speech, which is directly intended to injure the common good, this is going to be traditionally excluded. So it could be the private good of an individual, like libel, or it could be the common good, to where you are stating something in such a way which is going to promote bad morals. So, for example, traditionally pornography, indecent literature. These things were not allowed to be stated in public because of the effects that it would have. It would somehow violate the rights of other people to state these things or to publish these things. I'm sorry, boomer idea of freedom of speech, which means you can just say whatever you want. That's just fake. That's never been in our tradition. No responsible uh, legal scholar ever interpreted it like this. The right of the people to keep and bear arms. Yeah, this is going to be another one which going to cause people to seethe. The right of the people to keep and bear arms is not infringed by laws prohibiting the carrying of concealed weapons. The provision that no person shall be twice put to jeopardy does not prevent a second trial if upon the first trial the jury failed to agree or if the verdict was set aside upon the defendant's motion, nor does the provision of the same article that no one should be a witness against himself impair his obligation to testify if a prosecution against him be barred by the lapse of time, a pardon, or by statutory enactment. Nor does the provision that an accused person shall be confronted with the witnesses against him prevent the admission of dying declarations or the deposition of witnesses who have died since the formal trial, end quote, et cetera, et cetera. We can think of a number of these provisions going through all of our fundamental liberties, and nobody cries out against those. Oh, this is unconstitutional. Nobody says those things because this is just commonly recognized. These rights aren't somehow absolute, and they can be exercised in a certain way to violate other rights and bring forth some sort of public danger, and therefore these should be restricted. So, and then this is, I think, the idea of the violation of the public order. So I mentioned that a few times, and that's kind of in, as I mentioned in Catholic tradition, what is the reason for anti-blasphemy laws? Well, the reason for the anti-blasphemy laws is there's an intrinsic excellence to the glory of God, and the defamation of this glory is so vile that it's something that ought to be punished by the proper authorities. Whereas when it comes to the Anglo-American tradition, at least recent past few centuries, this tradition is going to state that it's rather more to do with the public order than it is with the intrinsic excellence of our Lord, Our Lady, the saints, etc. So this is brought forth by Oney v. Oklahoma City. So I mentioned that's the one from the 1940s, the Jehovah's Witness ones. And it says, quote, and I think this provides the principles very well. Always in civil society, two desires which in a degree are in conflict strive for supremacy. One is the desire of the individual to control and regulate his own actions in such a way as to promote what he conceives to be for his own good and advantage. And the other is to desire the whole to control the actions of the individual in such a way as to promote what is conceived to be for the common good or general welfare. So he's going to say there are these two principles. One is going to be the society in a certain way needs to direct the individual towards the common good, right? The general welfare. The individual cannot, in a way, grievously violate this general welfare because included and as a perfection of my individual good is actually the common good. So you cannot violate the common good and then claim individual liberty because in ways you're violating other people's liberties. But in the other way, obviously, there's also the concern for individual liberty and the individual regulation of one's own actions. So what it's saying is that there's a tension between these two principles that need to be resolved. The realization of the desire of the individual is personal liberty, and the effectuation of the desire of the whole is authority. Any use of authority is somehow going to restrain individual liberty. By individual liberty, I basically mean the way of acting in an unrestrained way. the way of acting in an unrestrained way. So it's a violation of personal liberty in this sense to throw a person in jail, right? Any use of authority is going to be a violation of personal liberty in this way. We're not using liberty in the theological sense that we often speak about. One form of government is designed to secure our form of government, American government, is designed to secure a nice balance between the two. When the pendulum swings too far towards the rights of the individual, liberty degenerates into license and anarchy. When it swings too far in the other way, authority becomes tyrannical. In the very nature of things, therefore, we must have an ordered liberty under law. For as was said by Chief Justice of the Supreme Court Hughes, civil liberties, as guaranteed by the Constitution, imply the existence of an organized society maintaining public order, without which liberty itself will be lost in the excesses of unrestrained abuses, right? So there are certain ways in which the public order needs to be maintained because it's only in the context of the public order that we're able to exercise responsibly our liberties. So, for example, let's say the legalization of, I'll say something that's already legal. The pornography, or we can look at another thing that's legal: excessive interest, debt slavery. Actually, excessive interest is going to be the better example. One cannot responsibly exercise their individual liberties if somebody is in a predatory way. They are given certain loans, and these loans are going to be impossible to pay off. So it is right and just for the government to get rid of cases of usury, because usury, these forms of excessive interest, or at least forms of excessive usury, although I think you should get rid of all of it, excessive usury is going to bring about wage slavery among people. And the public order cannot be maintained when you have wage slavery as generally applicable, or things that are highly addictive and destructive to the public morals, like pornography, certain drugs. These things are going to be so detrimental to the public order that people are not actually able to exercise liberty. So it's kind of a catch-22. You can't have an unrestrained and excessive allowance for individual liberty, because this is going to destroy the public order, wherein individual liberty is exercised when it comes to other people. So freedom of religion embraces two concepts: freedom to believe and freedom to act. So even in the Catholic tradition, we're going to distinguish between these two. So like an internal assent, and then the exercise or expression of this in the public order. So obviously, when it comes to freedom of belief, when it comes to the internal assent of the intellect, we cannot read Libertas by Pope Leo XIII. We cannot restrain somebody in this way when it comes to the internal furrows of conscience. But when it comes to the external action, yes, if this violates public order, public decency, we can reduce. Prosecute this freedom of action when it comes to freedom of religion. Everyone agrees with this, even if they don't know they agree with this. The first is absolute, but the second remains subject to. I don't like that language of absolute. The second remains subject to regulation for the protection of society. The city, under delegation of authority from the state in the exercise of police power, may enact ordinances to punish those who abuse these freedoms, to which we have averted by utterances inimical to the public welfare, tending to corruption of public morals, incite crime, or disturb the peace. Disturbance of the peace. And this is honestly, like, think about this right now. If you have somebody who goes out there and like plays really loud music that's offensive, then this person can be arrested, thrown in jail, and fined for disturbance of the peace, right? But when you have somebody who goes out there and performs a black mass, desecrating the Eucharist, something which in many different, at least in a general form, is held to be holy by the majority of Americans, you have a desecration of the Eucharist, which happens publicly, the majority religion of our country, and this is not considered to be disturbing the peace. This is not punished under blasphemy laws. It's ridiculous. It's hypocritical. Everyone knows this. The ordinance here involving prohibition of the use of violent, abusive, or insulting language and the display of insulting, profane, or abusive emblems, flags, or devices calculated to cause a breach of the peace, and the uttering, publication, circulation, or distribution of any words or language casting contemptuous reproach, or profane ridicule on God, Jesus Christ, the Holy Ghost, the Holy Scripture, or the Christian, or any other religion, calculated to cause a breach of the peace. On its face, it is plainly directed against actions calculated to cause a breach of the peace and disturb public order. Its object is to prevent the inciting of violence. End quote. So this is one argument that could be given, and that is given, for arguments against blasphemy. But as I said, we go a little bit further in this, and we don't merely think that blasphemy is wrong because it disturbs the public order, although it's obviously included in it. But there's nothing wrong with us arguing, if we're going to argue for a law, arguing in the framework of the laws of the country in which we reside. What would even in principle be wrong about this? It would make no sense to say, oh, we must throw off these arguments which are used because these arguments don't go far enough. What is this? Why would that even make sense? So, and then also I wanted to quote Chief Justice of the Michigan Supreme Court, Thomas Cooley, because he provides the general limitations and reasons which are given in the history of American jurisprudence. We can see a little bit clearer the distinction between the Catholic and the Anglo-American tradition. So he says, quote, "The constitutional liberty of speech and of the press, as we understand it, implies a right to freely utter and publish whatever the citizen may please, and to be protected against any responsibility for so doing, except so far as such publications, from their blasphemy, obscenity, or scandalous character, may be a public offense, or as by their falsehood and malice they may injuriously affect the standing, reputation, or pecuniary interests of individuals. It may be doubted," and this is the part where, as Catholics, we don't like this, "it may be doubted, however, if the punishment of blasphemy is based necessarily upon an admission of the divine origin or truth of the Christian religion, or incapable of being otherwise justified." So when it comes to the Anglo-American tradition, at least as it's been articulated in the last 200 or so years, the justifications which were given increasingly separated itself from the divine claim of Christianity, and more so relied very heavily upon arguments from the public order. So the arguments kind of went thus. It's like, well, the majority of our country is Christian, and to speak against the Christian religion is to denigrate morals, to incite public disorder. And in this way, liberty cannot be exercised when you have these violations of public order. Whereas in our tradition, obviously, while we could make that argument, it wouldn't contradict necessarily. We would also go further and make other arguments as well when it comes to the divine origin of Christianity. But it does not follow, because blasphemy is punishable as a crime, that therefore one is not at liberty to dispute or argue against the truth of the Christian religion or of any accepted dogma. Blasphemy implies something more than a denial of any of the truths of religion. And this is important as well, getting into the proper definition of blasphemy. Blasphemy implies something more than a denial of any of the truths of religion, even of the highest and most vital. A bad motive must exist. There must be a willful and malicious attempt to lessen men's reverence for the deity or of the accepted religion. So in our tradition, it's not simply the idea that somebody, let's say, somebody tweets out, "I don't believe that the Eucharist is the body and blood of Christ." In the Anglo-American tradition, that wouldn't somehow be against a blasphemy law. Rather, what would be against a blasphemy law is doing something like a black mass. What the purpose of a black mass and a simple declaration that one disagrees with a doctrine of Christianity, the purpose is different. So, under our tradition of law, the one would be included under blasphemy, the other would not. In the theological sense, we would both say that these are acts of infidelity, which, if said in a proper context, could be punished. But outside such willful and malicious attempt, there's a broad field for candid investigation and discussion. We are not always precluded from recognizing also, in the rules prescribed for the conduct of the citizen, the notorious fact that the prevailing religion in the states is Christian. Some acts would be offensive to public sentiment in a Christian community and would tend to public disorder, which in a Muslim or pagan country might be passed by without notice, or even be regarded as meritorious, just as some things would be considered indecent and worthy of reprobation and punishment as such in one state of society, which in another would be in accord with the prevailing customs, and therefore defended and protected by the laws. So he goes on to say that this is different between different societies. The next quote, a few blue pills in there. The next quote is from James Wilson. He's important because he was actually a founding father. He was an associate justice of the Supreme Court under George Washington. He wrote one of the most famous collections of lectures on jurisprudence, actually connected with Richard Hooker. Those who don't know Richard Hooker, he's a famous Anglican theologian. He wrote a few works, work on justification, a work on ecclesiastical law. But his lectures on law, James Wilson, very famous. He's a founding father, associate justice of the Supreme Court under Washington. He's going to be able to interpret this. When he says, quote, "Those crimes and offenses of which I have already treated attack some one of the natural rights of man or of society. There are other crimes and offenses which attack several of these natural rights. Of these, nuisances are the most extensive and diversified." So he's going to classify these under nuisances. A nuisance denotes anything which produces mischief, injury, or inconvenience. It is divided into two kinds, common and private. So basically for him, he's going to include this as a denial of certain rights of society. So society has the right, when it comes to the prevailing religion of that society, not to have the foundations for the general morals to be overturned and to be spoken against in ways as to incite them to abandonment of those morals. Like, for example, let's say I'm raising my kids, and I'm raising my kids in the Catholic faith. Somebody does not have a right to go out and to expose my children to various different contrary teachings against the morals in which I've decided to teach them in. People do not have the right to overturn this. So he's saying that this is a common nuisance in this way. It's against the rights of society. Now, not exactly the biggest fan of merely, yes, sure, it violates certain rights of society. Not the biggest fan of justifying blasphemy laws merely on the rights of society, not to be disturbed in the foundation for their morals. But, it's the general way in which traditionally this has been argued for. And he includes profaneness and blasphemy are offenses punishable by fine and by imprisonment, end quote. So, continuing on, we have Justice Joseph Story. I mentioned him as one of the great constitutional scholars of the 19th century, very well read in this. He wrote a commentary on the Constitution, which was basically meant to be a commentary on the Constitution looking at the preceding history and how that influenced the writing of the Constitution, and then a lot of the early writings from founding fathers. He said, quote, "Language more comprehensive for the complete protection of every variety of religious opinion could scarcely be used, and it must have been intended to extend equally to all sects, whether they believed in Christianity or not, and whether they were Jews or infidels, so that we are compelled to admit that although Christianity be a part of the common law of the state, yet it is so in this qualified sense, that its divine origin and truth are admitted, and therefore it is not to be maliciously and openly reviled and blasphemed against, to the annoyance of believers and the injury of the public." So basically what he's saying with this is that Christianity actually has a unique role when it comes to anti-blasphemy laws. In some of the more current and more recent iterations of anti-blasphemy laws, it actually extends to other religions as well. What he's saying is that because Christianity is unique in the founding and the commonality of people in this nation, that therefore we don't have anti-blasphemy laws for Muhammad and for others, because these blasphemy laws do not have the same basis as anti-blasphemy laws when it comes to the Christian faith. Although this does, as I mentioned, get changed later. So Justice Kent, he's another one. As I mentioned, he was the one that has the famous case, the 1811 case. He wrote, quote, "The court considered those blasphemous words uttered with such an intent as a breach of public morals, an offense against public decency." Again, this is going to be the basis for it. They were indicable on the same principle as the act of wantonly going naked or committing impure and indecent acts in the public streets. Well, when it comes to this, wantonly going around naked, apparently in the United States, this is not it's not a crime anymore. Unfortunate. It was not because Christianity was established by law, but because Christianity was in fact the religion of this country, the rule of our faith and practice, and the basis of the public morals. Such blasphemy was an outrage upon public decorum, and if sanctioned by our tribunals, would shock the moral sense of the country and degrade our character as a Christian people. End quote. And he actually says in the decision that he gave in People v. Ruggles, or however the frick you pronounce his name, says, quote, "The free, equal, and undisturbed enjoyment of religious opinion, whatever it may be, and free and decent discussions on any religious subject is granted and secured, but to revile with malicious and blasphemous contempt the religion professed by almost the whole community is an abuse of that right." Notice this is dependent upon this being the religion of the whole community. "Nor are we bound by any expressions in the Constitution, as some have strangely supposed, either not to punish at all or to punish indiscriminately the like attacks upon the religion of Muhammad or of the Grand Lama. And for this plain reason, that the case assumes that we are a Christian people, and the morality of the country is deeply engrafted upon Christianity, and not upon the doctrines or worship of those impostors." End quote. So besides, the tradition of law, because we've spoken a lot about the Anglo-American tradition, different justifications given by famous legal scholars, constitutional scholars, justices, court cases, etc., etc. But when it comes to the Catholic tradition, we see that the Catholic tradition is going to support the anti-blasphemy laws. We can see this from like the common praxis of Catholic kings everywhere and always until recently, actually, and up until like there was, for example, in Spain a few years back, I believe it was a few years back, in Spain, there was recently a prosecution, a fine which was given to an individual who said blasphemous things about the Blessed Virgin Mary. So this is something still in some Catholic nations which are on the law books, anti-blasphemy laws. So historically, yes, this was the praxis of Catholic nations, which obviously can be used as an indication of what the Catholic sense judges on this point. But we also see this being the case of certain magisterial teachings. So, for example, St. Pius V, he laid down a few laws that he himself imposed civilly against blasphemy. He said, quote, "According to the law herein laid down, the layman found guilty of blasphemy was fined. The fine was increased upon his second offense, and upon his third he was sent into exile." So you had first case of blasphemy, fine; second case, increased fine; third, exile. This is actually much lighter than what you get in Protestant countries. In Protestant countries, originally you just execute the person. Okay. The fine was increased if unable to pay the fine. So let's say the person's poor. He was, upon the first conviction, condemned to stand before the doors of the church, his hands tied behind him. For the second offense, he was flogged. So public flogging, the second offense. And for the third, his tongue was pierced, and he was sentenced to the galleys. So these were the laws which St. Pius V laid out. And we see this as well, and this is unfortunately not something which is commonly brought up, is we actually see case law for this from sacred scripture. Now, obviously, we are not bound to replicate in all of its details the civil case law in the Old Testament. We're not bound to replicate this in all of its details, but these do give us examples, give us just examples for how certain crimes are to be punished. So we see in Leviticus 24, we see a case of the blasphemy considered as a civil crime and it being civilly punished. It says, quote, this is verse 10 through 16. Now an Israelite woman's son, whose father was an Egyptian, went out among the people of Israel. And the Israelite woman's son and the man of Israel quarreled in the camp. And the Israelite woman's son blasphemed the name, so the name of God, and cursed. And they brought him to Moses. His mother's name was Shalomith, and the daughter of Dibri of the tribe of Dan. And they put him in custody till the will of the Lord should be declared to them. And the Lord said to Moses, bring out of the camp him who cursed, and let all who heard him lay their hands upon his head, and let all the congregation stone him. And say to the people of Israel, whoever curses his God shall bear his sin. He who blasphemes the name of the Lord shall be put to death. All the congregation shall stone him, the sojourner as well as the native, when he blasphemes the name, shall be put to death. End quote. So when it comes to sacred scripture, and a lot of, especially American law, multiple different states, including Maryland, my home state, used to punish blasphemy with death originally. But you have in different instances, as we see, different societies are going to punish the same crime in different ways, depending on the prudence of the legislator. Crimes, when it comes to crimes in civil law, these, similar actually to ecclesiastical law, these laws are going to be tempered by different circumstances. So obviously it's per se just to stone somebody for blasphemy. This just must be admitted. We can't say that God was giving unjust laws. But this doesn't mean that every single society should necessarily have this as their crime, as their punishment for the crime. So this is simply an example of a case law when it comes to punishment for blasphemy, to show the principle that it is just to go and to give anti-blasphemy laws to punish them. And then we can see from intrinsic arguments as well. We see for us, yes, we can look at the common good. This is actually when you read Dignitatis Humanae in some of the post-conciliar commentary that's given on this. We also see this from consideration of the Acta of the Second Vatican Council, that grave violations of the public good, the encouragement of public irreligion, these things are going to be able to be punished by the law. So we can still after Vatican II have anti-blasphemy laws. In fact, this is like the very justification which was given for anti-blasphemy laws in the Anglo-American tradition. It has to do with the common good. So insofar as the exercise of religion violates the common good, which would include blasphemy, this is something which can be punished by the civil magistrate. And beside this point, and this is what I'm going to close off with, and then I'll get into the super chats. Beside this point, we can also look at simply the rights of God. God, it is much worse for me to publicly blaspheme God than it is to commit libel against somebody. So very clearly, it is equally justified for us to punish words which are spoken blasphemously against God, against our Lord Jesus Christ, against his blessed mother, etc. It's very just for us to punish crimes which were committed against them just as much as it would be crimes committed against me or against anyone else, which obviously in accordance with any judicial system, certain amounts of speech, writing, these are going to be punished because it violates the good, the justice of another person. So when it comes to us, it is very clear that violations of the excellence, of the goodness of God should be punished because of his intrinsic excellence. So that's all that I have. Almost at an hour, but I'll get into some of those super chats, and then maybe I'll answer some regular chats as well. Oh yeah, then also during the Christian period of the Roman Empire, you also have the Code of Justinian punishes blasphemy by death. The Code of the Franks, which were actually ecclesiastically approved, punishes blasphemy by death. You look at a bunch of different ecclesiastically approved and generally used codes of law, which were Christian, punishes blasphemy by death. Okay, so cut off the tongue of those who say that Mary wasn't a perpetual virgin. Okay, thank you. Passion tide veil money. Appreciate it. Sorry, man, but America was never a Christian country. The Constitution is an enlightened secularist document. The founding fathers are Freemasons. Yeah, this is actually just completely a lie. Um, so you can read America, a Christian Nation. This was written by Justice. Uh, I know it's terrible. I can't remember. Can't remember his name right now. Hmm. It's from. It's actually from Holy Trinity v. United Justice Story. It is Justice Story. Oh no, it wasn't Justice Story that I was thinking about. It was a different Justice that I was thinking about. Brewer, Justice Brewer. That's who it was, Justice Brewer. The Supreme Court, 1892, declared that the United States is a Christian nation. Our greatest legal minds have always declared this to be the fact. And well, we can see this. We can see this from a number of cases. We can see it from the history of the United States, the general basis in which is given of the laws, the purpose which is given for the founding of each one of the individual colonies. So yes, of course, there were Enlightenment dorks who were included in the Constitutional Convention. Nobody's denying this. But to just from this, from the presence of Freemasons, from the presence of Enlightenment dorks, to say that somehow America in its founding is not a Christian nation is just completely ridiculous. I mean, okay, so if the United States is not a Christian nation, why do you have explicit mentions of Christianity in what? Like, I think it's 47 original state constitutions out of 50. Like, explain to me how this is not the case. How do we have in multiple different states? Actually, every single state at its founding, you could not unless you were a Christian. This changed with the Jew law in Maryland, but unless you were a Christian in all 13 original colonies, and this was the case in some states, unless you were a Protestant Christian, you could not be in state office in all of these different states. Some of them actually had establishment clauses for individual churches. It's just to denigrate the U.S. founding into somehow, it's just a bunch of Enlightenment thinkers and Freemasons. It's just completely retarded. I mean, this is just a completely retardo level 8th grade U.S. history, and plus some trad based aesthetics online stuff that I read. It's completely ridiculous, and this is why Pope Leo XIII calls the United States a well-ordered republic. You have multiple different popes who praise the United States system, who obviously we critique many different defects which are present in the American tradition. I'm obviously aware of this, but this does not somehow remove the fact that the United States, upon its founding, in its peoples, and its general morals, is Christian. That's just retarded. It concedes way too much. And DN, since you're Eastern Orthodox, I would definitely expect this bad take from you. That was a joke. That part was a joke, kind of. So, would you say the first two ways of St. Thomas and Q3A1 of Prima Pars good sources disprove the metaphysics of the Mormon God? I mean, oh man, I mean, when it comes to the Mormon God, I mean, they think that they're the Mormon God, basically every single article in the first 26 questions of Prima Pars 2 through 26, which is De De Uno, that's going to be contradicting things that the Mormons believe about their God. Anything from like body parts to carnal generation to just the having origin from another, to the multiplicity of gods. I mean, it's just ridiculous blasphemies are contained in the Mormon religion. So there's many different. I don't think there's almost anything in Prima Pars that they would agree with. Have you ever read about Thomas Paine 180ing on the Christendom of the U.S.? He goes full demon despite originally championing the opposite. Yeah, I have read this. So Thomas Paine, kind of retarded. he was kind of retarded. This is actually one of the considerations which I've read um, when the traditional blasphemy laws get explained. They're they're like they actually point to Thomas Paine. They say like, look, Thomas Paine, he said some retarded things about Christianity, and these were allowed to be printed in the United States. So they say that, well, Thomas Paine, he actually wasn't blaspheming because he didn't have those restrictions of intent that I mentioned from some of the authors, like a contemptuous desire to overturn public due order. Like he didn't state things in those ways, but rather they would say, "Oh, well, this is an academic work or a scholarly work or a general inquiry into something," and therefore, in the same way that the U.S. Constitution does not bar the printing of I don't know, the Mormon Bible or the Pearl of Great Price or something like that. In the same way, it doesn't bar the printing of that. So also does it not bar the printing of the works of Thomas Paine. It's kind of funny reading them absolutely dunk on Thomas Paine for this. But yes, these were known. These were eclectic. It's not like what you've heard from everyone that all of the founders were very irreligious and were Freemasonic, et cetera, et cetera. That's kind of a meme. Yes, of course, there were groups of influential individuals who were, but this is not generally representative of the American founding for sure. One could imagine a Monophysite saying that the canons of Chalcedon has a lot of good things in it. Doesn't make Chalcedon Monophysite. What are you even saying? What are you even saying? Basically, if you call the United States a Christian nation, you can mean a number of different things by this. You basically mean at the okay. Actually, I'll put it like this. Did the Monoph? Okay. So let me cook like this. So if Chalcedon said, "Hey, your bishops," because this is basically following our analogy, Chalcedon said, "Hey, your bishops need to be Monophysite." Would you say, "Oh, well, that's not a Monophysite council," because there were certain people who weren't Monophysite at the council? Like this is taking the analogy in a really weird way. Let's say that happened to be instituted at Chalcedon. In the founding of the United States, the people who went back to their constitutional conventions, state constitutional conventions, went back to make their state laws, said, "Hey, you have to be Christian in order to be a state official. If not, get the heck out of here, buddy. Oh, if you blaspheme, we're gonna kill you. We're gonna throw you in jail. Hey, actually, we're establishing this as our state religion, etc., etc." I mean, I could include many others, but or they go back and say, "Hey, this is a state made for the glory of Jesus Christ, etc., etc., for the pushing of the Christian religion, etc., etc." And you're like, "Oh wait, no, that's actually not a Christian founding, guys. They actually didn't intend this to be a Christian nation, have a Christian founding." Now, obviously, I'm Catholic, so I think there's serious flaws, and in a very real way, we can say that these individuals were not Christian insofar as they did not completely follow the religion of Jesus Christ. But to say that at least these weren't professedly Christian, or broadly or generally Christian, maybe of the heterodox strain, of course, is just to put your head in the sand. Okay, it's to completely ignore the reality of things. So I would like to think, at least, despite all of the flaws of my forefathers, that I am correcting and purifying and working upon, like Leo the 13th tells us to do. I'm correcting and moving forward and purifying the original intent, rather than just throwing the baby out with the bathwater and doing something completely different from what the founding fathers intended for the founding of the United States, and all of those who came before to establish the colonies of this great nation. So, yeah, you can read Justice Brewer, America, a Christian Nation, or United States, a Christian Nation. I can't remember which one it is. And he goes over the history of this. I mean, it's just a complete meme. It's completely ridiculous to say that the United States was, just all of them were Freemasons. It's ridiculous. Okay, let me see. Seems like they should have put that stuff in the document then. Well, you have to recognize that when it comes to the Constitution, the United States originally was meant to be something very similar to um It's very similar to the Holy Roman Empire. So the purpose of the United States was more or less there was, of course, a federal element to it, but in the pre-antebellum era, very much the states had a degree of liberty in their self-definition. So this is actually why you had to have the Bill of Rights in order to limit and restrict what Congress, and by extension the federal government, could do in relation to the states. So, for example, the Establishment Clause. The Establishment Clause isn't saying, "Hey, it's we shouldn't establish any religions in the United States." It's saying, "Well, it's not the role of Congress to establish a religion. It's the role of the states. If they want to, they can establish religion." Or with religious tests. Religious tests were widely, up until like the 1950s, were widely practiced throughout the United States. Religious tests of, do you believe in the Holy Trinity? Do you believe in the Bible? Et cetera, et cetera. Some states were a little bit broader like that. As I mentioned, Maryland, Jew law, 1820s, et cetera. But it's when it comes to the federal government, the Bill of Rights was meant to kind of tie their hands so the states would be comfortable with signing on to and agreeing with the Constitution. Because there was a period of time in which it looked like the Constitution was not going to pass. So they needed to add the Bill of Rights to make sure there was a cohesive agreement and this thing wouldn't just split up initially. But implied in all of this, in the Bill of Rights, was that there was, especially when it came to the First Amendment, there was a authority of different states to limit or choose not to limit the extension of these, which is why, as I mentioned, you have many different religious elements in each one of the states. So there's a reason why some of these things aren't included, and it's not because they were irreligious or they were anti-Christian. It's because they wanted these things to be decided in their proper sphere, so we could even have a union in the first place. Uh, Yeah, and there were several times in which this tried to get included. Yes, you're right about that as well. And even then, I mean, in traditional commentaries on law, um, there's nothing in the First Amendment against the recognition. As I mentioned, in the Supreme Court recognized the United States as a Christian nation in Holy Trinity. I think it's Holy Trinity v. United States. Um, in Holy Trinity v. United States, 1895, Supreme Court said America's a Christian nation. It's not something that has been many of our founding fathers, many state court decisions, state constitutions, etc., declared, okay, yeah, America's a Christian nation. This is the religion of America. This is actually part of the common law. Kent, he says, part of the common law of the United States is Christianity. So, yeah, it's not something which is even reasonable in an interpretation of U.S. history. This is just like the demonic lies of the post World War II Supreme Court, who wants to Jew you into believing that I didn't say Jew right there. Wants you wants to trick you into believing that somehow sodomy is a constitutional right, somehow gay marriage is a constitutional right, somehow adultery is a constitutional right. Like, are you kidding me? Yes, guys, adultery is a constitutional right, fornication is a constitutional right, blasphemy is a constitutional right. It's ridiculous. It's stupid. It's silly. It's never been recognized as such. Let's not concede a bunch of things to a bunch of people that hate us and want to destroy our country. Okay, please, I'm begging you. Oh, it's 1982, not 1980. 1892. Sorry, not 1895. Uh, what I was trying to say would St. Thomas's first two ways plus question 3, Article 1, whether God is a body, good ways demonstrate the Mormon concept of God cannot be God. Yeah, yes. But I mean, this follows what I meant by this is like there's so many different doctrines upon this follows. Like, for example, if you demonstrate that God is immutable, or that God is infinite, or that God is perfect, like in all of these cases, it's going to exclude the Mormon concept of God. That's what I meant by that. Yeah, no, I'll still allow it. I know about Gitlover v. New York. I think that case, I think that case was stupid. Why isn't Lincoln based? Let me introduce you guys to something. So you guys may not know about this. I'm hoping that this is not going to be copyrighted. If not, I'll just take it off in the replay. But since I'm from Maryland, we have a state, an awesome state anthem. Our state anthem, it's called Maryland, My Maryland. And this will red pill you. Oh, captions are unavailable. Let me go to this version. I hope this version. Oh no, this version's stupid because it doesn't have, you guys will just have to deal with that. But my state song is like a huge diss against Lincoln. If you pay attention, you will see why we're not a huge fan of Lincoln. Okay, it's a banger.
The despot's heel is on thy shore, Maryland, my Maryland. His torch is at thy temple door, Maryland, my.
And all the people saying, Maryland is in South, yeah, get destroyed by this. All of your state anthems are gay. Ours is about killing Lincoln. Yeah, so shut up about that. Sacred Trust, you mean Carol the Catholic? They were all Catholics.
Remember.
Yeah, by the way, Redeem Zoomer, you say that Catholics can't be American one time. You see one more time. Say it to my face, Redeem Zoomer. Say that Americans can't be Catholic. Say it one more time. You wop. Six Semper, you know what that's from? John Wilkes Booth shooting Lincoln in the head. Okay? So we have a reference to shooting Lincoln in the head in the Maryland state song. Call us Northern one more time. So awesome. I freaking love that. Yes. Yes, crabs for Christmas, another banger. I'm not gonna play crabs for Christmas. Okay, so how do we go about reinstating blasphemy laws in the modern United States? Well, it's just as easy as knowing the way that the legislature functions. I mean, state legislatures. There's certain state legislatures, probably most of them, in which it would be practically impossible now. So this is what this is going to do. Is this is just going to take getting involved in state level politics and being able to exert power in state level politics. That's basically it's basically it. So get involved in state level politics and work towards this amongst other goals. There's literally nothing stopping any of you guys. You guys, I'm assuming, are all adults and U.S. citizens. So you could literally just do this. There's nothing saying that you can't somehow get involved and try to bring about the ends of Catholic action. There's nothing saying that you can't. Okay, I've done it in my own ways. And by the way, if you would like to donate towards me doing that in my own ways, because often I do fund a lot of my own travel, time off of work, et cetera, et cetera. So if you want to help with the Catholic action that I do, you can go to christianbwagner.com/donate if you want to give a direct donation. All I'm going to say, basically for you, there's actually a video that somebody just sent me recently that I think explains the way in which these are this works very well. Let me see. Dang, who dang, I cannot find this. Oh yeah, here we go. Yeah, so they're kind of like libertarian tards, but I think they do get it, the way in which the state level politics is going to work. This right here, it's on FACL training.org/real-nature-of-politics. So if you wanna watch this, go ahead. that kind of explains things in general. But really, a lot of the times it's going to be infiltrating um, local organizations, getting friends with like-minded people. And then in this way, somehow it's not necessarily like I'm going to run for office and win office, or I'm going to somehow give really good arguments. Like this isn't the general way in which this type of thing works. It's going to work in many other ways, which that video is going to talk about. Wagner, Wikipedia says the Maryland song was removed in 2021. That was under Larry Hogan, and I am a uh, governor vacantist. I'm a governor vacantist. I think the last valid governor was O'Malley. Okay, it was not Larry Hogan. He was annoying. He was gay. Oh my gosh, Larry Hogan was so gay. Oh, that guy was the worst. Larry Hogan. He was just like, he's just like, I hate Trump. I'm rejecting your endorsement. You're mean, Donald. Like he was a Republican governor of Maryland. Like how bad do you think he probably? It was very very bad. Honestly, like there's a sort of saying of like at least a prostitute's an honest woman. You know, at least she's obviously doing bad things, but at least she's being honest about it. She's not like um a woman who's fornicating and pretending that she's chaste. So it's like at least like a Democratic governor would be, like an honest guy in governing terribly. Like Larry Hogan, he was just kind of LARPing. He's a rhino. It's awful. I hope he doesn't go any further. I'm glad he lost the Senate seat. He got owned in the Senate seat by some black woman. It's so funny. Yeah, Larry Hogan, that's what happens when you remove our state anthem. Huh? You lost the Senate seat to a black woman? Wow, funny that happens. I hope your career's dead right now, Larry. Guy, I do not like him. Larry Hogan sucks. Mm, okay. Wait, is Larry Hogan Catholic? Oh no, O'Malley's Catholic. That's who it is. Okay. I think that's all. Been a little over an hour. So yeah, Larry Hogan, BTF Sotro. Anyways, that's all. I hope that you enjoyed this. Remember, like, subscribe, share, all that. And as always, God bless.